Get the show on the road here. It is 7:30 p.m. on September 22nd, 2021. This is the Municipal Land Use Board of the Borough of River Edge. This meeting is of the Municipal Land Use Board of the Borough of River Edge is being held remotely and recorded via Zoom due to the COVID-19 pandemic and is in compliance with the provisions of Executive Orders 103 and 104, the Open Public Meetings Act, and associated regulations. Notice of this meeting was published in the Bergen Record on January 20th, 2021, and the Ridgewood News on January 22nd, 2021, posted on the front doors of Borough Hall and posted on the borough's website. The notice included the dial-in and login information necessary for public participation and access to this meeting remotely. A copy of the agenda for this meeting was made available on the borough's website near the posting of the meeting notice and included the dial-in and login information. During the public comment period of this meeting, if you would like to make a public comment, please press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. The board will address you by name or by the last 4 digits of your telephone number. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address prior to making a public comment. Members of the public were permitted to submit written comments prior to the meeting via mail or email, which will be read during the public comment period. That said, welcome everyone. A couple of housekeeping items this evening before we call the roll. We're going to have a 10:30 curfew this evening, and one of the agenda items has been carried at the request of the applicant and will not be heard this evening. That is the Breton Matter. That's 17 Elizabeth Street, block 1407, lot 2. So if there's anybody here that's in attendance looking to hear that particular application, it will not be heard tonight. It will be heard on October 27th. Ed, correct me if I'm wrong.
You're correct.
Thank you, sir. That said, Marina, would you do the honors and call the roll, please?
We also are going to carry the Perkins application as well. I think that was decided a little bit earlier.
Okay.
That the Perkins application will be carried to the October 13th, 2021 meeting at the request of the applicant.
Right.
That's correct.
Okay.
Thank you for that.
Yep. And the roll. Mr. Mayor.
Present.
Mr. Caslin.
Here.
Ms. Boland. Here. Mr. Merman.
Here.
Mr. Grasso is excused tonight. Mr. Cray.
Here.
Mr. Ericalian is absent tonight.
He's excused. Yep.
Okay, Mr. Councilman Kanigo.
Here.
Mr. Gibbons.
Here.
Mr. Pfeffer.
Here.
Mr. Esposito.
Here.
Okay, and for the record, both alternates will be seated to vote tonight, and Mr. Behrens and Mr. Costa are also present.
Okay, thank you, Marina. The first item for this evening, we have no minutes at this point, so we'll move to the memorializations. The first item on the memorializations is for Gloria Juliana, 3 June Court, block 1004, lot 22. Resolution granting variances for maximum lot coverage and maximum improved lot cover. Oh, I'm sorry, I'm reading the wrong one. Granting variances for maximum fence height. Any comments from the board on the proposed resolution? There being none, I'd like to entertain a motion to approve the resolution, please.
So moved. Gibbons.
Thank you,
Second.
Mr. Gibbons.
Second.
Second, Mr. Esposito. Thank you, sir. All in favor?
Aye. Aye.
Any opposed, any abstained, or do we have to call a roll?
We can do a voice vote, but Mr. Merman cannot vote on this memorialization because he voted no at the last meeting.
Okay, so Mr. Merman, you'll abstain from this vote. All right, my apologies. Maybe we just call the roll then, Marina.
Okay. Mr. Mayor,
Yes.
Mr. Caslin,
Yes.
Ms. Boland,
Yes.
Mr. Cray,
Yes.
Councilman Kenigo,
Yes.
Mr. Gibbons,
Yes.
Mr. Pfeffer,
Yes.
Mr. Esposito.
Yes.
Okay, the motion passes.
Okay, thank you. The next item under memorialization is for I apologize if I'm mispronouncing this, Nagarajan Subramanian, 927 Magnolia Avenue, Block 102, Lot 4. Resolution granting variances for maximum lot coverage and maximum improved lot coverage. Comments to the proposed resolution, please. Okay, there being no comments, may I have a motion to approve the resolution as presented?
So moved. Gibbons.
Thank you, Mr. Gibbons.
Second, Merman.
Thank you, Mr. Merman. Marina, when you're ready?
Okay, Mr. Mayor,
Yes.
Mr. Caslin,
Yes.
Ms. Boland,
Yes.
Mr. Merman,
Yes.
Mr. Cray,
Yes.
Councilman Kenigo,
Yes.
Mr. Gibbons,
Yes.
Mr. Pfeffer,
Yes.
Mr. Esposito.
Yes.
Okay, the motion passes.
Okay, thank you, everyone. Next on our agenda this evening, we have no applications for completeness review and no new business, so we will move into old business. The first item on the agenda there is Narmadan Kumarasamy, 364 Valley Road, Block 905, Lot 27. This was an application seeking to install deck additions, shed, walkway, and above-ground pool, and seeking lot coverage variances. This application was previously heard back on August 11th of 2021. I believe the applicant is with us this evening. Good evening, folks.
Evening.
Okay,
And just for the record, at the August 11th meeting, the applicants were both sworn to provide testimony on the application, and they will still be under oath today.
okay. So we've received an additional submission from you modifying your site plan. Tom, have you had a chance to look at that?
I don't think Tom's with us anymore.
Oh, yeah.
Oh, I think
Oh,
he's.
no, there he is.
He's
He
in.
came back. Although I think he's present.
He's frozen.
Now he's
Oh,
gone.
God. All right, we'll give Tom a chance to come back.
There we go.
There he is. All right, Tom.
Sorry, my internet's on the fritz, and I was going to try to connect through my phone. So if it happened, call back in.
Okay.
I assume you've turned to me to talk about the issue of whether or not a pool constitutes a temporary structure, specifically an above ground pool. Is that fair?
Well, I was actually just turning the floor to you just to find out if you've had the opportunity to review the subsequent submission that was made by the applicant under cover of September 6, 2021.
Yes, I have. And I guess since I opened up my mouth and made an assumption, why don't I start with that first issue? So Marina, Rob, and I had gone through that issue as to whether or not an above ground pool, should be considered temporary or not. And there's a few definitions that can guide the board in making that determination. And the first is the borough's definition of improved lot coverage, which is one of the variances at hand. And that definition is the percentage of lot area which is improved with principal and accessory buildings, structures, and uses, including but not limited to driveways, parking areas, garages, and other man-made improvements. It's important to note that pools are specifically exempted as being considered accessory buildings and uses, but there's that last term man-made improvements, which is not 100% clear in terms of whether something's temporary or not. There's no further definitions in the borough ordinance that provide any further guidance, but a gentleman by the name of Harvey Moskowitz has prepared a series of planning definitions that are generally referenced in the planning profession and have been accepted by boards and in case law. And he does have a definition for temporary structure, which is a structure that is erected without any foundation or footings and is removed when the designated time period, activity, or use for which the temporary structure was erected has ceased. And I came across one other definition through the American Planning Association, which I'll paraphrase, generally talks about any temporary structure is one that is not fixed and does not have a foundation. So some definitions do have a time period associated with it, and others just talk about whether or not it has a fixed foundation or is, essentially attached to the land. And the borough's definition the borough's ordinance dating back to the 80s, I don't think has contemplated some of the new pool products that are out there, which include, kiddie pools, sort of these 3-foot inflatable pools that you could buy, on the internet or Costco or what have you. Then you have the standard above ground pool with, I guess they're aluminum walls, and then your typical in-ground pool. So I guess there is a question of where do you draw the line in terms of what is temporary or not. I think the distinction certainly between an above ground pool and an in-ground pool is that there is no foundation per se. There may be let's say a gravel base or a sand base for an above ground pool, but it generally is sits at grade and doesn't impact underground. My understanding is that the borough's past policy has been that.
You're breaking up, Tom.
He may have to leave and come back again.
Yeah.
There we go.
So Tom, we lost about the last 10 or 15 seconds of what you were saying.
I'm sorry about that.
That's okay.
So based on those definitions, and as I understand the borough's past policy, I think you could deem them temporary, but I think the board should try to take a firm stance one way or another as to whether or not they're temporary moving forward. And further, once that position is made, that it should be specifically reflected in the code at some point in time as this issue will continue. So does anyone have any questions about those definitions?
Any questions from the board for Tom?
Yeah, I actually have one, just for kind of clarity. With an in-ground pool, then would you say the fact that you're pouring in some cases you're going to pour in an old concrete pool, but a lot of times now you wouldn't be.
Mhm.
There would be no foundation with an in-ground pool. Is that a reasonable assumption?
Well, whether you call it a foundation or not, I think you'd have a subsurface structure with, typically you don't just stick a liner in the ground. There's usually, I guess, a base and concrete or something that might constitute, something of permanence.
Okay, so because I guess that's what I'm asking is there a definitional difference between an in-ground and above ground pool based on the temporary structure?
Well, part of it has to do with, I think an above ground pool, other than getting the water out, could be removed from the property more readily than an in-ground pool, which would require, heavy equipment. That might be one distinction. But again, I mean, it's up to the board, to go either way, and it should be a borough policy, and not just my interpretation of things.
I have a question. Tom, you mentioned something at the beginning that I just wanted to get a little more clarity about. You
Okay.
said pools were exempted. Can you elaborate on that? In what sense, in what context were they exempted?
Well, there's a section of the ordinance that deals with accessory structures and uses specifically. And at some point in time, the ordinance was changed to exempt pools entirely because a separate section was written to address pools. So they're dealt with separately in the ordinance.
So in that separate section dealing with pools, there's nothing that you were able to glean that would lean towards permanent or temporary.
It only talks about essentially pools having a depth of 12 inches or greater, and establishing certain setbacks and maintenance requirements, but really doesn't talk about coverage or above ground versus in ground. Just has that one depth consideration, and I think that may even be outdated relative to the building code, as I understand.
Thank you.
Just a comment on this, more than a question. Obviously with the pandemic, there's been a lot of Intex, one of the brand names, and I'm sure every other house in town has one of these things now. You'd be hard pressed to monitor above ground pools and coverage issues, and you would have to get very specific in terms of if it's an aluminum side versus a vinyl side. How do you create that distinction? Personally, I would think, an above ground pool is something that can be removed, like you said, without heavy equipment, and it is something that's happening a lot more. Maybe it is something that the borough has to look at more, but, me personally, I would think, an above ground pool is removable enough, to allow an exception on these, because they are becoming much more prevalent. And it is becoming a much more, enjoyable thing for people to have in their yards, with what's going on. And obviously with what's going on will not continue forever, but, people do enjoy having their yards, with the pools. And I think it'd be very difficult to monitor if you were to say that they have to be. Any above ground pool would be impervious coverage. So just my 2 cents.
So, just again, kind of a question and a comment. The concern, I'm assuming the concern with coverage here is the typical one, which is, rainwater runoff, the typical issues that arise with a high percentage of impervious coverage. There's also, the aesthetics of how much ground coverage do you have or not. But I guess, my concern or question is, what is the assessment of what happens in large rain events with pools? Are we assuming that the pool is capturing that, or are we assuming it's going out onto the rest of the surface and then we've got the same issues that we always do? Because if it's the second, a 15-year temporary structure is not really temporary if the issue here is ground or runoff. If it's there for a month, that's one thing. If it's there for 15 years, it's something entirely different. So I guess, I'm looking for any information or feedback on what do we anticipate actually happens with the pool as a reservoir for rainwater when there's a large rain event.
If I can interject for 1 minute,
Sure.
Whether it's temporary or not, the structure, if it's going to be impervious. So under the soil moving, they're going to have to capture whatever that area is for stormwater management. And again, 2 weeks ago, we saw what happened in this town. And I don't want to mention the different blocks and addresses, but whether it counts as impervious or pervious, it's impervious no matter what, whether it's temporary or permanent. So even if you say it doesn't count towards the lot coverage, it still counts towards stormwater management. Period, end of story. I don't know who wants to argue with me tonight with that, but under the soil moving, absolutely, that's how it works. And basically, it's every square foot you put in, you got to hold 2 gallons of water. And Eileen is looking at me. I mean, she knows it. I ran into the good doctor recently in the Golf Galaxy on Route 17, and we had a conversation, and she knows exactly who I'm talking about. That's the rule of thumb. You add a square foot, you need to get a pail that's 2 gallons deep, and that's it. And that's basically the rule of thumb.
Rob, can I maybe reiterate your point and tell me if I'm wrong? So even if the board decides that above ground pools are temporary. They still have to meet the stormwater drainage requirements.
1000%.
They still have to meet the setbacks, and they still have to
Yeah,
get
I
a
mean,
permit. because
The
there's a
argument
filter.
and different pool guys that come in, the argument is, well, wait a minute. The pool water is going to be below X amount of feet under the coping. So it acts as a reservoir. So if we get 2 inches of rain or 3 inches or 5 inches, or like we did a couple of weeks ago, probably 6 or 7 inches of rain. But again, it can overflow. And then it's 100% impervious once it overflows. So you leave the hose in the pool. I mean, you can come up with any scenario you want, but whatever that area is, you have to manage the stormwater as a result of that. But again, one has nothing to do with the other. If the board decides it's a temporary structure, so be it. And I agree with you, Mr. Cray. If it's there for 15 years, how temporary is it? It's not. But again, you went back to the definitions, and Tom and I spoke earlier today. It comes back, it's up to the board whether or not they want to allow above ground pools. And then does this open the floodgates in River Edge? So whoever wanted an in-ground pool decides to do an above ground pool, and that's how they get around the regulations. Or it should go back to the mayor and council and let the mayor and council decide whether or not they want to change the ordinance and the definition, and then send it back to the board. But I think the board should make a decision one way or another tonight, and that's what Tom and I discussed earlier.
Well, I think based on the information we're hearing, I mean, let me go around and pull the board before I go any further. Any further questions on the materials that have been submitted? New materials from anybody?
I had one question on the lot coverage calculation. Are the 3 steps off the back of the deck included in that calculation?
No, they are not. And I realize that if they do need to be covered, we can make those steps significantly smaller.
Okay, but it'll still change the percentage to some degree.
Right. And if they need to be counted, we can adjust the size of the deck to meet whatever limit it has to be at.
Okay. That was the only question I had.
Okay. Ms. Boland, any questions from you?
I do have a question for Tom as far as a building permit for pools, above ground pools. Do you know that if they need building permits, or can they?
They do. And because if they have a pump or some sort of electrical component, they require a building component, and that's regardless of the size.
Well, that would be a good way to regulate whether you're comparing it to the kiddie pools or blow up pools. Anything that needs a building permit would make sense to me that it would be coverage, because like 15 years might even be a short amount of time. It could last longer than that. So that's my opinion.
Okay. Just one distinction, just because it was a zoning, as of COVID, it's become a zoning issue. Are these Intex pools that Mr. Gibbons mentioned that tend to be up for a couple months and then removed? Would that still fall into that category? It would still
Do they need
technically
to
need a
build?
permit.
They need a building permit for those?
Yeah, technically, is what I'm told, because they
And
have
they-
a pump and a filter. Yeah.
And do they stay up longer than a few months?
The ones I've seen are generally from Memorial Day to Labor Day. But it
So what
varies.
happens?
That's
So what
typically
happens, Tom? Those pools are disassembled and they're stored, like they're component pieces, and they get stored in a shed or a storage unit, something to that effect?
I assume. I mean, I don't think they're they could handle the winter problem. You know what I mean? They're made of, I guess, generally vinyl. Some are inflatable. But yeah, they're generally put up for the swimming season, taken down and stored. I mean, the product itself has probably been around for 15 years, but there's been more with, since the COVID situation.
Yeah, they're definitely not long-term structures.
But again, it's just a question of where to draw the line, just so, as the reviewing agent, I know where that line is, I guess. If that makes sense.
Okay. I'm sorry, Eileen, any additional questions?
No, I do want to go on record for having watched the video, the YouTube video, and sending my certification in. So I did listen to the meeting of August 11th.
Yes.
Okay, thank you.
Mhm.
Mr. Pfeffer, any questions from you?
I don't have any other questions. I'm prepared. I have an opinion, but I don't know if it's time for that.
Okay, well, we'll come back to that. Hold that
Yeah.
thought if you would. Mr. Esposito, any questions?
No questions at this time.
Okay, Mr. Mayor?
No questions at this time.
Thank you, sir. Councilman?
No questions. I have comments, but if we're gonna be able to do comments, I'll reserve them.
Okay, thank you, sir. Mr. Merman?
I have a question to Mr. Costa. If I understand what you said, if I understand you correctly, you're saying from a stormwater management perspective, a temporary pool or above ground pool would still require some kind of subsurface disposal of water.
Correct. Yes.
Okay, so following on that, that would apply to this application also, is that correct?
Correct.
Okay, I rest my case.
Okay.
Okay. I think at this point now we have to come to a determination as a board. Exactly the question of the above ground pool and its nature as to whether or not it's temporary or more than temporary, for lack of a better term at this point. I think it's going to be hard to paint into a corner to come up with something, exactly what is temporary based on the components of the pool, because if you've got various technologies from what I'm hearing, I think it sounds more to me more like it's a fix with a foundation than not. But then again, we have the timing element to consider as well, and whether there's some limitations that get put on there. And I guess the questions to the applicant, your intention is to leave this pool once it's built. You're not intending to take it up and put it down every season. Is that correct?
Oh, that's correct.
Okay. So I think that's going to be part of our question, and I'm interested to hear your opinions at this time. So I think, Mr. Pfeffer, let me start with you.
Sure, thank you. Well, I think that while we can all come up with our own interpretations of the law right now, I do think that it seems that it's arguably ambiguous, and reasonable people can disagree on what the law means and what it requires and what's left out and what needs to be modified. So I think that under those circumstances, I would certainly be in favor of the council taking this up at some point and really, coming up with a more, with just a clearer guideline in the rules, so that we can go forward, not debating whether something is temporary or not, but we can really look at the guidelines and see if it fits or it doesn't fit. And so on that basis, I would say, since it's ambiguous, I wouldn't want to penalize the applicant in that situation where the rule can be argued different ways by different people. So, I wouldn't want to penalize them for that. I would want to know whether the applicant would be willing to modify the structure of the pool since there are these technologies where you can disassemble a pool. I realize it's not the same kind of pool, but it might at least satisfy some board members that if it's a type of pool that can be disassembled at the end of the season and then reassembled next year, at the beginning of the season, maybe that might satisfy some concerns. And regardless of the answer to that, it seems to me that what we're saying is whether the pool is permanent or temporary, there's still a stormwater drainage issue. And so regardless of how we decide on whether something is permanent or temporary, there should be some mitigation steps taken just to deal with the stormwater issue. So you can have the pool and still be required to mitigate the overflow issues. So, I guess in summary, I would say that the applicant shouldn't be penalized because the law is not clear. But at the same time, we should still strive to see if there's a solution that would involve restructuring the pool, or at least putting in some mitigation steps to deal with overflow issues. Thank you.
Okay, thank you, Mr. Pfeffer. Eileen?
So I still feel that it should be coverage. And I also think that the steps, I think everything on the property should be included as coverage. That's how I feel.
Okay, thank you. Councilman, I know you had mentioned you had comments.
Yes, sir. Thank you. First of all, I respectfully disagree with Mr. Pfeffer on a couple of points. I don't believe that if we decide that this is in fact permanent, that this would result in a penalty. We're not here about penalizing these individuals. They have come before us to ask for a variance of our ordinances, and whether they can exceed what we've determined first as a council and then as land use board, that is the correct sizing for these types of properties. So they're asking us to way exceed that, and more than the 40% that we've already asked about. And the ambiguity built into the ordinance is to give the land use board an opportunity to take cases case by case. I don't think that the council can really legislate each and every possible eventuality, situation, issue that may arise when these applications are brought before the land use board. So it's the land use board that has to, reach an opinion on this. And I think, the fine people on this board are very capable, if not more than capable, to make these decisions because of their background and experience, especially on this board. As far as the decking itself is concerned and the pool, I think, look, yes, reasonable people can disagree, but also I think that in the law, we all know that there's a reasonable person standard that you want to look at. And I think that a reasonable person might be able to say that if a structure is up year after year after year for, 5 years, 10 years, 15 years, 20 years, that structure is permanent, even if it has to be replaced at some point because weather and conditions destroy it. In this particular case, if we're looking at case-by-case basis, these individuals have built a deck around this pool. So the pool is meant to be a permanent part of the house. And as Mr. Costa said, we have to address the rainwater situation. So I think it would be okay to say in this particular case, given the size of the property, the size of the pool that is there, that was built, the deck that was built onto it, and the fact that it goes over that 40% threshold that we've, kind of stuck to so closely. I think in this particular case, it's okay for us to say, no, this is a permanent structure and it should count towards the numbers. And then if another case presents different facts, it's okay for us to look at the other case as a land use board and address those particular facts and as they may affect the land use situation. So those are my thoughts on the matter in general. And I thank everybody for your time.
Thank you, Councilman. Mr. Mayor? Thoughts?
Yes.
Sorry. I don't know if the applicant has really explained on the record what the changes are. They submitted the papers, but I didn't know if we wanted to give them a chance to explain the changes.
I was just going to ask, is it possible for us to make a comment? I appreciated what Mr. Pfeffer said as well. The timeline for us was it was very difficult to try to understand like you said, it was unambiguous, and I spent a lot of time searching the website. I visited the building department and asked a lot of questions. We spoke with Tom a couple times, and our understanding after the pool permit was approved was that this above ground pool wouldn't count towards lot coverage. And I completely appreciate that there are many different factors that go into this decision. It's just what I wanted to mention was that when we did build a pool in the summer, we didn't realize it would count towards lot coverage, because in the beginning, our plan had been just build a deck. But our deck builder told us one day, a couple years, if we decide to get a above ground pool, we'll end up spending thousands of dollars trying to accommodate that. And we're like, you know what, maybe let's try the pool permit. And that's kind of how this all came about. So we do apologize that we didn't realize this would count towards lot coverage. Do you want to go towards?
Well, can I interject real quick? Because I
Sure.
think a lot of this does have to do with my guidance, and I know I wasn't at the first meeting on this. So the applicant had reached out in the planning phase when they were deciding what to do in terms of installing a pool. And because I was operating under the assumption that above ground pools had been considered for some time to be temporary, that's the guidance that I gave. And the building department then issued them a permit to install their pool. And as I understand it, the above ground pool is actually on the property today, but the decking is not. I believe that's the case.
That's correct.
And they moved forward in good faith with the direction they were given. And again, if I was wrong, I fully own that and accept that moving forward. I just, hope the board would take that into consideration. And I certainly understand all the points that have been made, and we can certainly adjust that policy moving forward. But I just wanted to be clear in terms of how things have played out, and that the applicant has moved forward in good faith. And now might also be a good time for the applicant to explain the plan revision, since we've turned things over to the applicant. So do you guys have a revised plan that maybe you could share on screen that would help us understand where we are?
Can I just ask one question, Tom? So.
Yeah.
I didn't know, I wasn't aware of this, but if the building department issued the permit for the pool?
Well, so I act as the zoning officer. I received the zoning permit applications. In this case, it was for an above ground pool because
Okay.
they, moved forward under my guidance that it wouldn't be counted toward lot coverage. So they applied for the pool.
Okay,
I signed off from a zoning perspective, and then the building department issued the permit.
okay, so, all right, and it's in, so the pool's in. I
Pool's
wasn't in
in.
the backyard, so the pool was there.
Right.
Okay,
The deck and the shed, as I understand it, are not though.
Correct.
Right. So those are the discussion points for tonight, essentially.
Can I ask Marina a question?
Yes.
Marina, is it possible to make a decision tonight and in that decision state that this particular decision is to be given no precedential effect
right.
In future decisions? It is for certain factors as they've been detailed tonight, and that's what the board may be taking into consideration if they decide to allow this to be termed temporary, but we still want to address the temporary versus permanent distinction down the line.
Yes, so every decision that the board makes is made on an individual. I'm getting a little bit of feedback. Every decision that the board makes is decided individually and doesn't set precedent for any other property in the borough. When Tom made the decision as the zoning officer to grant the pool permit, he was operating as the zoning officer, interpreting the borough code as it's written, and the board can accept that and then make a decision or request in the future that the council change the definition based on the ambiguities that the zoning officer has found.
I would also add to that, the land use board functioning as a zoning board can also interpret the ordinance, and we can change that policy tonight, essentially based on what I'm hearing. That sounds like where we might be headed. So
If I can, Marina, no disrespect. If a building permit was issued for the pool was inspected, the pool is in, they relied on the permit. They're probably stopped. I mean, if the permit was actually given to them, the horse ran the track.
Yeah, I don't know. I didn't know if the board had remembered or was aware that this pool has already been installed.
Right.
That's why I wanted to make sure that.
If the pool was installed with a valid permit, and
Yeah.
again, it sounds like it was a valid permit, I think the pool at this point is moot.
We're not asking them to take down the pool. They want
Right.
to add to the decking around.
Right,
So
the,
that's
the
what we're
issue
talking
is
about.
increasing the coverage with the deck and
Deck.
the shed is,
The pool's
Right.
fine. You
Right.
just don't have any room to build a deck.
Right, and the issue is whether it's considered as temporary or permanent, because if it's temporary, then they're at the 40%. If it's permanent, they're at 42.
But Tom, one question, you know, the letter of denial said it was not included in the coverage?
so in an abundance, so this is the first time frankly I've ever had to deal with an above ground pool becoming a coverage issue. But because I didn't know how the board would opine on this issue 100%, I had them notice for the worst case scenario, that
Okay.
meaning that the pool counted toward the coverage.
Okay, so you count, all right.
But in the letter, I indicated that my understanding is that in the past, above ground pools were counted as temporary. However, wrong that may be, but that's the guidance that I gave to them.
And so based on what Mr. Costa and Mr. Behrens have said, I think that the board can make a decision saying the applicant can have X amount of coverage and not include the pool in the actual lot coverage calculation, because that's the advice that the zoning officer gave. The applicant should show all of the other requirements to have a variance granted, any mitigation efforts they're going to put in. And then the board can make a decision at a later date about how to interpret this particular section of the ordinance that's causing problems.
Okay, so why don't we continue with the applicant? I'm sorry, to get you the rest of your testimony on the record here as to your submission.
Sure. So I'm just going to share my screen.
Screen one.
Can everyone see my screen?
Yes.
All right, this is the revised proposal that we submitted. Again, the above ground pool is already in. We have an existing small deck that is right here. So we wanted to expand the deck to 15 by 22, and that comes out to 294 square feet when I exclude the bump out here. And we have one step leading up to a pool deck, which would allow us easier access to the pool, especially important for our mother-in-law, because currently with the pool ground steps below, it's difficult to get to. So that would add 66 square feet. And then we would also add a shed for 80 square feet. We eliminated the walkway. We reduced the size of the shed, and we also significantly reduced the size of the deck as compared to our original proposal. We also submitted an aerial review of our neighborhood, which I'm not sure if you had seen, but our property basically, we have 3 immediately adjacent neighbors who have either pools, decks, and or sheds that are similar in size to us. And there are additional properties on our block too, which have similar structures that we are requesting. A lot of whom have lot coverage that is much more than we are seeking.
If I could jump in, I just wanted to summarize where the coverage is as proposed. I think the previous revised coverage, the original coverage without the pool was 48.5%. As the applicant mentioned, he removed the side walkway, adjusted the size of the deck and the shed. And so the property as it stands, excluding the pool, is at 34.6%. If you add the larger portion of the deck at 294 square feet, that's an additional 3.6%. The smaller portion of the deck is about 66 square feet, but that gets canceled out because there's an existing landing and steps that are about 64 square feet. So that shouldn't be factored in. There's the shed that's 80 square feet. That's about 1%. So if you take the existing 34.6%, add the deck 3.6%, and 1.1% for the shed, you arrive at 39.2%. Then there's the question of the pool. If you include the pool, it's 42%.
What's the lot size, Tony? Like 8,000?
8,160.6 square feet.
Did not, Dick Merman here, did not the applicant state that the steps, the 3 steps were not in his calculation?
That should be addressed. Yes, it has not been
Yes.
addressed.
So the overall calculation or configuration, size and all has to be adjusted accordingly.
And I think we heard the applicant say earlier they would address that.
Okay,
Okay, anything further? From the applicant?
No. Do you have anything else to say, Russ?
No, just to answer Mr. Merman, the 3 steps, if we made it now, it will go to the below 40% without the pool. Because as Tom had mentioned, it was 39.6 and we can keep it at the 0.4%.
Can I just ask the applicant, just to be clear, you're going to comply with the stormwater requirements in terms of installing a seepage pit as may be required by the borough engineer? Is that fair to say?
Yeah.
Yes.
But we do have, and whatever you
Whatever
guys
is
need,
required.
yeah.
Okay, you, I believe you'll be installing a fence because you have to, because you have a pool now.
We do
would
have,
a
yeah.
fence.
Okay, is there any landscaping proposed?
As of right now, no.
Okay. All right, I have nothing further at this time.
Okay, if I could ask the applicant to stop sharing your screen.
Sure.
Great, thank you. Okay. Now, based on the materials submitted, we're going around, I think, polling folks. I think I left off with Mr. Mayor.
Yes, so a couple of comments first. We've had 3 storms over the last couple of years, and even more over the last decade, that have flooded the town repeatedly. We have concerns on Eastbrook, we have concerns on Voorhees, we have concerns all around the town. And we had flooding that even in areas which weren't flooded normally, caused people to have to demolish their basements. So this is a serious issue, impervious coverage. However, I also recognize that due to a vagueness about a above ground pool, that you were granted a permit and therefore granted, and the pool already exists. However, the third point I'd like to make is that the ordinance is for 35%. So we consider whether we should go above that. And the more and more we have weather conditions like we're having, the more and more we realize that we need to be more stringent or more protective of permeable coverage in the town. So I guess my comment would be, I could probably go for another 2% because that would be 120% of what is permitted. 35% times 1.2 is 42%. But I really couldn't go past that. And right now without the steps, we're talking about 42.8. With the steps, looks like we're up to 43 or 43.5. So if the applicant is willing to modify down to 42%, given the special circumstances, given the advice that they were given and the permit they were granted, I would, as an individual, not as the mayor, I would, as an individual of the land use board, be able to vote yes. But that's as far as I'm willing to go in these special circumstances. Normally, I could not go past 40%. But I realize that this case, especially the granting of the above ground pool, makes for a difficult case to judge. And that's where I am. And I'm wondering if the applicant could modify so that they don't, with the pool, go past 42%, which is 2% more than we normally give, and 7% what is the maximum by ordinance. But that would be my, I don't know if that's going to be the position of other people, where they're going to stick to the 40%. If they do, I think they're serving the town well. If they choose to use standard I'm kind of creating for this special circumstances, that's fine too. Everyone votes independently, but I'm wondering if the applicant could be comfortable with reducing the deck or the shed so that they do not exceed 42%.
Would you be amenable to that?
Yes, that's not a problem. We can adjust the deck to be down to 42% so that it includes the steps.
Okay. Anything further, Mr. Mayor?
No, that's it. Thank you very much.
Thank you. Mr. Gibbons?
I would be fine with that as well. You know, with these different circumstances, you know, and I don't know if I, you know, look at it differently than some of the people on the board, you know, looking at above ground pools as a special circumstance, you know, as I mentioned earlier. So if you can get those, you know, the overall project to 42%, you know, I'd certainly be on board with that. You know, I think you could definitely make that work. You know, I think going forward, we do definitely need to look at the above ground pools and figure out a way to make them work, and, you know, and maybe require even more stormwater management than we would do for a deck or a patio or something like that. You know, but I think there's definitely something to be done here to allow these to go forward and allow people to have what is becoming more common in backyards. So I would agree with the mayor, you know, certainly if you can get it to 42, you'd have my vote as well.
Thank you, Mr. Gibbons. Mr. Esposito?
I would say the same thing. I mean, if it gets to 42%, I would vote yes on that. Nothing any more than that, that's for sure.
Okay, thank you, sir. Mr. Craig?
Yeah, I guess just one comment on really on the temporary structure issue. I think there was language that said something along the lines that when the event is finished or complete, then the structure would be taken down. And I think, you know, from the standpoint, not tonight's situation is a little different in that, again, we're dealing with an existing situation, the permit having been issued, the pool's in place. But I think for the future, I think we do have some guidelines that really aren't that ambiguous. I don't think it's unreasonable to say that, you know, my child, you know, living for 15 or 16 years and he's now out of the house, so now I don't need the pool. It's not the end of an event. A temporary event would be, you know, there's an you know, a celebration. We're putting a tent up for a wedding or a party. I mean, those are temporary structures. Something that we're building for 15 years. There's not a 15-year event that's going to end, and now we're going to take it down. So I think we have reasonable guidance within the language that exists. So I'm not sure that there's really a tremendous amount of ambiguity other than the past practice. I mean, obviously the past practice is in place. If we're going to adapt that because of greater risk, greater rain events that we've been experiencing, I think there's reasonable guidance within the language of the code. And that's it.
Okay, thank you, Mr. Cray. Mr. Merman?
Under the circumstances, I agree with the mayor. And likewise, I believe this motion will contain a proviso that stormwater management be addressed with the borough engineer. And I also firmly agree that the above ground pool definition has to be codified.
Okay, thank you, sir. So from my perspective, as you see, we as a board, we do like to work with applicants to the extent we possibly can, certainly when it's individuals such as yourselves with their residents and their use and enjoyment of their residence. But within that, we have a certain obligation as it relates to our board to make sure that certain standards are met. And as you've heard, there are a variety of considerations here. But that being said, I think I would be in support as well of the proposal that's been extended here based on these, specific circumstances as it relates to your particular project at this point. So with that being said, Mr. Councilman.
I'm sorry, I just wanted to chime in because we had more information given to us after I spoke and then the mayor made this proposal. I'm just going to throw it out there, and I hate to be the contrarian one tonight, but I just feel that in the past, I don't know, 6 months, we've had several meetings where people have come to us and asked us to move past the 40% threshold. And we all said to them that we were a hard no on moving past that 40% threshold. I don't see the circumstances herein as warranting us making that exception in this case. This is a very big house, a big property with a lot of coverage on it already, especially in light of what we just saw with Ida. I think we just as the mayor said, we have to be a little more stringent. And I think that the only thing that will happen if we allow 40% to become 42% is that we are going to hear stories from everybody who comes forth after this saying, come on, you let it happen once, 42%, I've got my own special circumstances. And then we've moved the meter up from what was really a 35%, it should be 35%, to 40% is the max that we'll allow. So now all of a sudden we're looking at 42%, maybe even creeping up to 45%. So for that, for based on all that, and especially based on what we all told all the other people who came before us asking exactly for the same thing, I think that we should say 40% is the hard line that we have to draw in these situations. And I'm very sorry. I hate to say no, but I just feel that in good conscience, in order to back up what I said before, I have to stay in the same line and in the same vein. Thank you.
Point taken. Thank you, Councilman. Any further comment from the board? Okay. At this time, I'd like to open the meeting to the public for comment. May I have a motion, please?
So made, Merman.
Thank you, Mr. Merman. Second, Mr. Givens. All in favor?
Aye.
Any opposed, any abstain? There being none. We're now open to the public. Marina,
And
do you have any?
there are no attendees.
There are no attendees. Okay, thank you. At this time, I'd like to entertain a motion to close the meeting to the public.
So made, Merman.
Thank you, Mr. Merman. Second, Mr. Gibbons. Thank you. All in favor?
Aye.
Aye.
Any opposed, any abstain? There being none, we're now closed to the public. At this time, I open it to the board for a motion on the application, please.
So I will make a motion. It's the first time I've made a motion to approve an application or even to reject an application. So forgive me if I don't get the wording exactly right. I would move to approve the application subject to the agreement of the applicants to comply with all drainage mitigation requirements, as well as to set a maximum impervious coverage of no more than 42% on the property.
And I just want to have Tom clarify, there's variance for improved lot coverage and also lot coverage. Am I correct?
Let me get the letter up. You are correct. I'm looking at the percentage.
Okay. And yeah, I just want to get that number correct.
Could Mr. Pfeffer also include the motion that the above ground pool is considered a part of the 42%?
Yes,
Yes.
Thank you.
I'd like to suggest that the motion include a statement saying under the current circumstances, which would cover the situation with the building department and so forth.
I would accept that as an amendment if that's what's being asked.
Thank you.
Is there a second to Mr. Pfeffer's motion?
Second.
So moved.
I just
I'm
want,
seconding.
so I just wanted to confirm what the lot coverage percentage is gonna be.
Right, I'm trying to do the math. real
Oh,
quick,
okay,
right?
sorry.
Yeah, because it changed, so bear with me.
Okay,
Okay, I'll give you a chance to do that calculation.
And of course, this would include the steps that are not yet included in the drawing or the documents presented.
yes.
So based on what I just calculated, and the calculator disappeared on my screen, it's approximately 31.5%. And it was originally, the proposal was originally 37%, and it's been reduced to 31.5% lot coverage.
Okay, and the applicants would be willing to comply with the 42% improved lot coverage, including the pool and the steps, and then 31.5% lot coverage. Is that correct? Okay,
Yes.
thank you. So I have a motion from Mr. Pfeffer as amended with the additional language, and then a second from the mayor.
Yes.
Okay, maybe before we vote, Marina, if you could just recap the motion.
Okay, so under the current conditions, the board approves this application, subject to borough engineer review for stormwater management with an improved lot coverage up to 42% with the above ground pool included and the steps, and a lot coverage of 31.5%.
Okay, and that has Mr. Merman's comments and as well about stormwater.
I think I got that in there.
Okay. Okay, so the motion was made by Mr. Pfeffer and was seconded by the mayor. When you're ready, would you kindly call the roll, please?
Okay. Mr. Mayor,
Yes.
Mr. Caslin,
Yes.
Ms. Boland,
Yes.
okay, Mr. Merman,
Yes.
Mr. Cray,
Yes.
Councilman Kiniga,
No.
Mr. Gibbons,
Yes.
Mr. Pfeffer,
yes.
Mr. Esposito.
Yes.
Okay, the motion passes.
Okay. Thank you, folks, for your time coming in. This was a challenging one, as you've seen, but we appreciate your patience as we navigated through the process, and I thank the board for their diligent and conscious discussion of the matters at hand. So,
Thank you so much for your time, and we've learned a lot this summer, to say the least, and we appreciate your patience.
thank you.
Congratulations.
Good night. Well,
Mr. Caslin,
Mr. Mayor.
could we tie up the conversation about above ground pools so that we make sure that it is my opinion that above ground pool would count towards coverage, that above ground pools are not temporary. And I think it was suggested by Mr. Behrings or Ms. Stinley that we could make make a position on that without having to go to council. Is that correct?
I mean, as I mentioned before, the land use board functioning as a zoning board has the ability to interpret the ordinance. The application that was before the board was not necessarily an interpretation application, but I think the board, Marina, correct me if I'm wrong, but I think the board can provide guidance accordingly.
That is the case. I'm not sure if the mayor or council person would be able to participate if the board is acting as a zoning board of adjustment.
So maybe we could leave it because, well, we're not doing either the D variance, but we could certainly leave the meeting prior to discussion, and maybe the discussion could be postponed until we left. There is also something, Mr. Castellan, and that I sent to you about stormwater being put out onto the street.
Mr. Mayor, can I interrupt a second?
Sure.
On the previous thought of above ground pools, can I suggest maybe that Tom with Marina draft something for the planning board to consider a definition that we could vote on, and thereby I would assume directly codify it, at least for the board and the acting especially as the ZBA.
Yeah, whatever you guys think is best, because Council President Canigo and I can't stay for that debate. I'm just saying that I think if it's possible for some direction to be given, even if it's directing for our professionals to make a recommendation at the next meeting, just so it doesn't remain a loose end.
Mayor,
Yeah.
if I can interject, I think the simple thing is to have Marina send a letter to the council, and the council just adds that to the definition of above ground pools is part of it.
So one of my, based on going off of that, for some other towns, that's something that I do frequently is draft changes that are recommended by the planning board. And then present them to the council. I'm not sure if that's something you would want to do, or if you would want me to sit in on a committee meeting, get your ideas on what would need to be changed or wanted to be changed, and then recommends that the council review those changes.
Yeah, I think for the benefit of the board right now, I think it would be helpful to see what the current language says so that we can have a meaningful discussion about, what types of changes should be made, to address the matter going forward.
Right. I think we need to get a definition of what
Right.
a long-term above ground pool is and a short-term above ground pool. Because some people will keep up those in-techs for a couple of years. So what is that definition of what, if there is a difference between the two, or we keep treating them the same?
Yeah, and maybe it's a permitting situation where you have to get a permit every so often, and you have to make sure you're complying with the regulations. Maybe it's a 2-year or 5-year period permit or something to that effect, and you have to demonstrate that there's no negative impact. I'm just throwing that out there, but I think
I'm wondering at this point whether Councilman Canigo and I should be here for this debate. I'm thinking not.
Well, I think the next steps are just on this particular issue is just going to be for Marina just to circulate the current language as it reads to the board for the board to review, and then I think that we can take steps from there. So I think that.
And just one other step, not to debate it, just to ask a question: is it possible to find out what a New Milford and Oradell, other towns are doing as well? Not that we want to follow anyone else's lead, but to see what options are out there that we might not have considered. And
this gets back to the broader issue that we've been talking about on a couple of other fronts too, in terms of signage, in terms of some of the other issues that we're looking at as a board and as committees. So it'd be one of those things that adds to the list if when we schedule our separate work session to try to go through these with a more specific approach to the various topics, instead of trying to do it at the end of a hearing, heard applications at night. So,
and if you'd like me to sit in on any of those meetings, I'd be happy to, and so I could take notes and then make the changes and draft some sort of memo to the board or letter, things like that.
That'd be great. Okay.
So this is, there's an additional zoning board issue that Council President Kenigo and I can't be a part of, and it's some pump discharges. And I sent, very late, I apologize, but I sent a copy to Mr. Merman, to Mr. Castling, and Tom, I think I sent it to you, Mr. Barings, about an issue that came up, and the DPW superintendent felt that the issue was not his jurisdiction. It was really the zoning board's jurisdiction. And maybe, Chris, you can send it to Marina, and that can also be reviewed, because what happens is some people are discharging their sump pumps into the street. And so that would also be an issue that I don't believe Council President Kenigo or I can be a part of. But I did forward that to you today, not for discussion today, but simply to mention that it might be a part of a discussion, general discussion in the future.
Okay. Thank you.
You're welcome.
So our special meeting that we plan on to discuss the other items that we've been talking about, the mayor and Councilman Snego cannot be part of that meeting as well?
Well, it depends on what type of action the board is going to try and make. If the board's just making a recommendation to the council, saying these are the things that we'd like the council to change, then they can participate as well. But if the board is taking action to make a policy as the zoning board of adjustment, then they might not be able to participate fully.
So we'd have to craft an agenda that kind of works for that purpose.
Yeah, I would think it would be planning board. We're not trying to interpret the ordinance, we're just making recommendations for some changes.
Right.
As opposed to interpreting a definition of a temporary structure. Okay,
Sure. That's right.
great.
Do we have any guidance on when that meeting might actually happen?
What,
That was gonna
when,
be one of the things that was on the list to raise tonight. There's actually two things, that being one of them. I think we'll try to do it, not on, obviously not on, maybe we'll do it outside of a week of a meeting, do an off week, if that works for everybody. If we do, I mean, a Wednesday at 7:30, does that seem to fit everybody's schedule? You don't have to give me an answer now, but just give that some thought. We'll throw that out as the first opportunity. We'll poll the group and see what works best. Start there, and then we'll. Does anybody have problems with Wednesdays right now?
I do have a conflict typically on the opposite Wednesdays, but often those meetings are canceled with lack of agenda, so I would be up there.
Okay. All right. So all right. How much advance notice do you usually get at that? Not.
Maybe a week. I might have a week's notice.
Okay, but we have to, Marina, we have to notice this particular meeting, don't we?
Yeah, we will have to publish notice of the meeting.
Okay. Does Tuesday nights work, or Thursday nights work for?
Yeah, that works for me, if we can be included, depending on the agenda.
Okay. All right,
I would
so
I would say it varies, but why don't you pick some dates?
we'll pick Tuesdays or Thursday dates. We'll send that around in an email to the group, and we'll see which one works best, and we'll try to get something on the calendar. So that's item one. Item two is our board secretary, Lou Grasso, is not going to be with us for the next several meetings due to personal issues. And we are at a point where he is, because of that, he's resigned as not as a board member, but he's resigned his position as secretary of the board. So we are in need of a board member to become the acting secretary for the board. So is there anybody at this particular moment in time who has an interest in fulfilling that role?
I think I'd be interested in that.
Okay. Marina, do we have to vote formally on that?
think that what we should do is make a nomination and then take a board vote on the nomination. And if there's any additional nominees.
Okay, so aside from Mr. Gibbons, is there anybody else interested in acting as secretary for the board? Okay. Then at that point, can I,
Mervyn will make a motion that Mr. Gibbons serve as, is it, you want an acting one or a full one?
he's gonna be,
This would be to finish the position that Lou.
To finish Mr. Grasso's term as board secretary.
Second.
Thank you both.
Okay. We can just do a voice vote.
voice vote, okay. All in favor of the motion?
Aye.
Any opposed, any abstain? There being none, Mr. Gibbons, congratulations. You are the new secretary.
Thank you.
Thank you for
Look
stepping
at
in.
those pencils.
I didn't know I was getting promoted tonight.
Get your signing hand worked out.
I got my pen.
All right. That's it on the agenda this evening. Anybody else have anything further? All right, Mr. Merman, go watch your ball game.
Yeah, all right, I'll make a motion that we adjourn.
Have a second. Second, Mr. Gibbons, all in favor?
Aye.
Aye.
Any opposed, any abstain? We are closed. Thank you, everyone. Appreciate your time this evening.
Good
Good
night.
night. Great work,
Good night.
everyone. Thank you.
Good night.
All right.